Hey guys, we're Group I, and we're going to be discussing a commercial lease dispute between Opoworth and 3R Limited. I am Kamal, and I'm with Max, Alan, and Fateh. The address of the property was 4038 Great North Road, Cowston, Auckland, which is in New Zealand, obviously. Essentially, Opoworth asserts that 3R breached the lease by undertaking additions and alterations to the lease's premises without first obtaining written consent. 3R Limited filed a notice of opposition and claimed that those works were not additions or alterations, as those words are used within the lease. They also claim that consent was given orally during telephone conversation in May 2019 between Mr. Wei of Opoworth and Mr. Ping on its behalf, and even went further on to say that they requested in emails for consent. Therefore, 3R Limited claimed that Opoworth had unreasonably withheld consent. In the end, 3R Limited breached the lease by failing to obtain the landlord's consent to additions and alterations undertaken in breach of Section 22.1 of the lease. The Property Law Act notice under Section 246 was validly issued, and 3R failed to remedy its breach of the lease with the time reasonably specified in that notice. Therefore, Opoworth was entitled to cancel the lease and possession of the property, and was the successful party, meaning they were able to recover its reasonable costs and disbursements from 3R Limited.
Hey guys, this is Max. I'll be covering the problems of the case. So 3R Global Limited undertook alterations to their multi-unit property without a formal written consent to do so. This was required and clearly outlined in the deed of lease. And the issue was that Mr. Wei thought a telephone call was sufficient enough to do so. He thought he had permission to undertake these alterations, which is not the case. These alterations that he had performed created compliance issues for the entire building complex. Fire systems were now breaching regulations required. The compliance issues directly related to the building's warrant of fitness. This failure to receive a warrant of fitness later on, in which it did on the 24th of July, 2019, could also then jeopardize insurance covers for the entire building complex, which stressed out Mr. Wei. This stressful pressure put upon himself consisted of things such as insurance premiums being increased, or the insurer could avoid the insurance cover entirely for the entire building complex. This not only stresses out Mr. Wei, but also all the tenants within the building. Most importantly, this breach of regulations put other tenants' lives at risk, as the fire systems now weren't functioning properly and could increase the price that these tenants pay towards their outgoings if they must within their lease agreement, as these alterations performed by Mr. Ping made fire systems not work in their needed regulatory system. Another major issue is that Mr. Ping, who is behind 3R Global Limited, is that he now believed that what he had done was within the regulations of the deed of lease. He believed that the phone call was sufficient to be able to perform the alterations and was very stubborn to believe otherwise. He argued and was not reasonable with Mr. Wei to get rid of any of these alterations he'd performed. And because of this, Mr. Wei ended up filing to cancel the lease.
So hey guys, I'm Alan. I'll be discussing the outcome of the case. So after the court case, it was decided that 3R has breached the lease agreements by modifying the property without receiving consent from their landlord, meaning that they are liable and must provide remedies to Opoworth associated with the alterations and the additions to the property. The court decided that a reasonable amount of time to remedy all this would be 2 months, in which 3R would have to hire a third-party professional building inspector at their own expense to come and inspect if the modifications done to the property are safe and does not breach any form of building regulations. If it needs to comply with the building acts and does not require resource consents or building consents, then it's fine. If it does not comply and all consents are obtained later and a code compliance certificate is issued, 3R also must give a copy of the consent and certificates to Opoworth. All of this is done at 3R's expense to remedy the modifications of the property. However, the actual amount of remedy that 3R had to give to Opoworth and the status of the property afterwards was not disclosed.
Hi guys, I'm Fateh, and today I'll be talking about the proactive management and how such disputes can be avoided. A property manager will manage the property with good communication with the tenant. They will maintain compliance of the building and ensure safety and well-being of the multi-unit complex occupants. Complications relating to fire safety and failing warrant of fitness have drastic effects on the lessor. This leads to increase in building expenses with potentially higher insurance costs. Furthermore, dangerous modifications reduce the building safety and put the occupants' lives at risk. Such complications are easily avoidable by monitoring the alterations undertaken in the complex and applying risk management frameworks such as ISO 31000. A proactive manager would have clearly outlined the expectations of the lease agreement to the lessee. Mr. Pink should have been made aware that modifications cannot be carried out without formal written consent. As per ISO 31000 framework, a proactive management could remove the risk source. This is achieved by conducting more quality screening checks. Choosing a better quality lessee will reduce the chances of such disputes. The likelihood of this dispute occurring could be changed. This would be done by maintaining good communication between lessor and lessee. Regular inspections could also avoid the lessee from undertaking modifications, which may cause compliance issues. Furthermore, when the solution of this problem is not reached and situation does escalate, a property manager could have involved a mediator. The mediator would attempt to resolve the dispute without escalating the issue further.
So, in conclusion, 3R breached the lease by undertaking additions and alterations to the lease premises without first obtaining written consent. And as an outcome of this, Opoworth was the successful party and was entitled to cancel the lease and possession of the property. They were also able to recover their reasonable costs and disbursements from 3R Limited. This could have been prevented by better communication between the lessee and lessor, or they could have removed the resource through the 3100 ISO framework, or they could have lastly, as Fateh said, got a mediator involved. So thanks guys for listening, and that's it.